Setting after-death instructions for handling one's property can be accomplished by creating a last will and testament. In Nebraska, wills can be drafted rather simply and, best of all, often without seeking legal advice from an expensive attorney. In this video, we'll discuss what wills are and their importance, what's included in will documents, legal requirements in Nebraska, and how and where to create an official will. First, let's begin by looking at wills and their importance. A last will and testament, simply known as a will, is a legal document that sets instructions on how an individual's property is to be distributed after their death. Wills establish the beneficiaries of the deceased estate and the portion they'll receive. It's highly recommended for all adults to have a will, especially those who are elderly or facing life-threatening conditions. But now, what occurs if no will is left? A person who passes away without a will loses full control of who inherits their property. Instead, Nebraska's state succession laws will determine how the deceased's assets are managed. The deceased spouse or children typically inherit the property by default in such cases. However, disputes can arise between loved ones regarding rightful heirs when the state handles and disperses the estate, as opposed to the person whom the property belongs. Fortunately, any uncertainty can be avoided by drafting a clear will document, and often without an expensive attorney required. A person of sound mind can draft a will in Nebraska with the following information on the document: their full name and residing address, the information of their personal representative, also known as the executor, who will distribute the assets accordingly, the names of all beneficiaries, and a thorough list of the property each shall receive, any additional terms and conditions, and the signatures of the testator and 2 witness signatures. And finally, let's review some legal requirements in Nebraska. Last will and testaments in Nebraska must be signed by the person to whom the will belongs, known as the testator, in the presence of at least 2 trusted and competent witnesses. Though optional, it is recommended that both witnesses be disinterested parties. Disinterested parties are individuals who do not stand to personally benefit from the will or receive a share of the testator's estate. Once created and signed, the document will be legally binding. Multiple copies can be given to trusted individuals such as the executor of the will for safekeeping. We're eForms, the biggest database of legal documents. We have created state-specific last will and testament templates specifically designed for Nebraska that are quick and easy to fill out. Our software generates an official document after you select your desired will instructions and name all of your beneficiaries. Click on the link below to begin creating your will. And don't forget to like and subscribe for more daily videos.